Hi everyone, welcome to EPG Pathshala. This module is titled A Socio-Historical Perspective of the Protection of Women from Domestic Violence Act. The author of this module is Dr. Aparna Chandra, Assistant Professor of Law at the National Law University, Delhi. I am Rinal Satish, Associate Professor of Law at the National Law University, Delhi, and I will be presenting this module. The objectives of this module are to introduce readers to the sociological and legal concept of domestic violence, its causes, manifestations, incidents, and consequences, to provide an overview of the international and domestic legal reform movement that led to the legal recognition of domestic violence as a human rights violation and a public wrong, to explain the features of the criminal law provisions dealing with domestic violence, to critically analyze the limitations of using a criminal law framework to address domestic violence, to facilitate an understanding of the need for and features of the Protection of Women from Domestic Violence Act 2005. So let's look at the introduction here. The violence against women is a global phenomenon. It is a manifestation of historically unequal power relations between men and women, which have led to domination and discrimination against women by men, and to prevention of the full advancement of women, and that violence against women is one of the crucial social mechanisms by which women are forced into subordinate positions compared with men. Familial spaces are some of the most frequent sites of violence against women. Women routinely face a range of abuses within the home, including abuse which is verbal, emotional, physical, psychological, economic, and sexual. Through these forms of abuse, women are subordinated and controlled, and their rights to bodily integrity, violence free life with dignity, autonomy, and equality denied. At the same time, however, until recently, the law did not recognize violence within the family or domestic violence as a matter of public concern. Such violence is hidden within the privacy of the home, and the law has traditionally been hesitant to intrude in this private sphere. In addition, patriarchal notions of male superiority and entitlement over women's bodies, as well as social norms that justify exertion of control and power over women, have resulted in a discourse that normalizes violence against women within the family. Such social norms aid in creating a culture of silence around violence within families, such that those within do not wish to speak about it and those outside do not want to hear it. Empirical studies reveal that women do not speak up about such violence due to lack of alternatives, fear of being separated from loved ones, and feelings of guilt and shame as they feel that they are responsible for the violence. Many complainants are faced with eviction from the family home, are cut off without maintenance, and are unable to follow the complaint precisely because they have no means to do so. This structure of control and domination over women within families is further perpetuated by state inaction and interference in combating such violence. State functionaries are reared in the same patriarchal traditions that justify familial violence, often treat domestic violence as a trivial matter or one which should be resolved without state intervention. The extent of normalization of violence within families is evidenced by the fact that the National Family Health Survey conducted by the Government of India in 2005-2006 found that 54% of men and 51% women believe that a husband is justified in beating his wife under certain circumstances. Data from this survey also revealed that 40% of women in the age group of 15 to 49 had experienced some form of spousal violence in their lifetimes. However, most women were hesitant to report or take any action against such violence. According to the survey, only 23.8% of women had sought redress for the violence. Two-thirds of respondents who had faced violence had never spoken to anyone about it. Such acceptance of violence and the silence surrounding it stem from the complex power relations between gender and generation that underlie the family, the ideology and structure of dependence, or the sexual division of labor, all of which strengthen patterns of inequality and oppression of women and children. Domestic violence as a human rights violation, legal recognition of domestic violence as a violation of human rights came about in the later part of the 20th century. Driven by demands of women's rights groups and feminist reconstruction of the personal as the political, the law could no longer be oblivious to the grave consequences of domestic violence upon the lives of women. Women's rights groups organized not only locally but also internationally for recognition that violence against women, including domestic violence, was a violation of women's human rights. While the adoption of the Convention on the Elimination of All Forms of Discrimination Against Women (CEDAW) in 1979 gave impetus to the movement, it was through the UN Declaration on the Elimination of Violence Against Women 1994 that domestic violence was given focused attention. The preambular statement of the Declaration reaffirmed the conclusion in the Economic and Social Council Resolution 1990/15 of 24 May 1990 that violence against women in the family and society was pervasive and cut across lines of income, class, and culture, and had to be matched by urgent and effective steps to eliminate its incidence. The Declaration defined violence against women to encompass but not be limited to physical, sexual, and psychological violence occurring in the family, including battering, sexual abuse of female children in the household, dowry related violence, marital rape, female genital mutilation, and other traditional practices harmful to women, non spousal violence, and violence related to exploitation. Domestic violence as a human rights violation was reaffirmed in the Beijing Declaration and Platform for Action 1995. Legal reforms movement in India, criminal sanctions alongside this international context, women's rights groups in India had also been agitating for legal reform to recognize and redress violence. Though the Constitution of India recognizes women's equality and right against non-discrimination, these rights were not directly applicable within the private sphere of the home. Matrimonial laws did not provide for cruelty as a ground for divorce, separation, and maintenance. However, this was wholly inadequate to redress domestic violence. A big lacuna in the law was that upon seeking legal redress, a woman could be thrown out of a matrimonial home. She had no right to reside in either her matrimonial home or her natal home. This was a significant barrier to accessing legal remedies. Added to this was the practice of providing minimal monetary maintenance, which was more often than not wholly inadequate to meet daily needs. There was, however, no punitive sanction against domestic violence. In the 1970s and early 1980s, women's rights groups mobilized public and political opinion on addressing violence against women as a criminal act. This resulted in two amendments to the criminal laws in the 80s. In 1983, Section 498A was added to the Indian Penal Code, which criminalized cruelty by the husband and his relatives against the wife. In 1986, Section 304B was added to the Indian Penal Code, by which dowry deaths were criminalized. Alongside these amendments, procedural changes were made to Section 113A of the Indian Evidence Act and Section 198A of the Criminal Procedure Code. Section 498A states as follows: husband or relative of a husband of a woman subjecting her to cruelty, whoever being the husband or the relative of the husband of a woman subject the woman to cruelty shall be punishable with imprisonment for a term which may extend to 3 years, and shall also be liable to fine. Explanation: for the purposes of this section, cruelty means a. Any willful conduct which is of such a nature as is likely to drive the woman to commit suicide, or to cause grave injury or danger to life, limb, or health, whether mental or physical, of woman, or b. harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her of any person related to her to meet such demand. As is evident from above, Section 498A was confined to domestic violence against a married woman by a husband and in-laws. It defined cruelty to include not only physical but also mental abuse. Additionally, Section 498A was not confined to cruelty in the context of demands for dowry. Explanation A to Section 498A clarified that cruelty included any willful conduct which is likely to drive a woman to commit suicide or to cause grave injury or danger to the life, limb, or physical or mental health of a woman. Section 498A was made cognizable, non-compoundable, and non-bailable. The offence under the section was non-compoundable in recognition of the fact that a married woman generally has lesser economic resources and bargaining power as compared to her marital family. Therefore, she is vulnerable to being coerced into compounding these offences and thereby letting perpetrators of domestic violence get away with their criminal acts. Section 304B was enacted in 1986 in response to rising number of dowry deaths which were often passed off as accidents and suicides. Since the death usually occurred within the four walls of the home and with the complicity of the marital family, there was often little evidence of what had actually transpired. To address this concern, Section 304B provides as follows: Dowry death, subsection 1, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of a marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. Explanation says, for the purpose of this subsection, dowry shall have the same meaning as in section 2 of the Dowry Prohibition Act 1961. Subsection 2 says, whoever commits dowry death shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. In addition to section 304B, the Indian Evidence Act was amended to include section 113 capital B. This section provides, and I quote, presumption as to dowry death when the question is whether a person has committed the dowry death of a woman and it's shown that soon before her death such woman has been subjected by such person to cruelty or harassment for or in connection with any demand for dowry, the court shall presume that such person had caused the dowry debt. The explanation says, for the purpose of this section, dowry debt shall have the same meaning as in section 304B of the Indian Penal Code. Taken together, section 304B and section 113B provide that when a woman dies within 7 years of marriage in unnatural circumstances, and it's proved that soon before her death she was subjected to cruelty or harassment for dowry by her husband or his relatives, then the court shall presume that the husband or relatives concerned caused the death. In addition to these provisions, section 113A of the Indian Evidence Act was enacted in 1983 to address the concern that women were often subjected to such extreme abuse that they committed suicide. Section 113A provides, and I quote, presumption as to abatement of suicide by a married woman when the question is whether the commission of suicide by a woman had been abetted by a husband or any relative of a husband, and it's shown that she had committed suicide within a period of 7 years from the date of her marriage, and that a husband or such relative of a husband had subjected her to cruelty, the court may presume, having regard to all the other circumstances of the case, that such suicide had been abetted by her husband or by such relative of her husband. The section provides that if a woman commits suicide within 7 years of marriage and it is proved that she had been subjected to cruelty by her husband or his relatives, then the husband or such relatives may be presumed to have abetted her suicide under section 306 of the Indian Penal Code. The 1983 and 86 amendments played a very important role in breaking the silence around normalization of domestic violence. Feminist scholars believe that since law is seen as the primary legitimating discourse, and it's believed therefore that legal criminalization would socially delegitimize the practice, limitations of criminalizing domestic violence is something that we'll look at next. However, experience showed that these reforms had limited impact in either reorienting societal norms or in providing effective legal redress for domestic violence. The focus of these amendments was on violence against the wife by her marital relations. This excluded other forms of domestic violence, as for example, within the natal family or within bigamous marriages, extramarital or other forms of intimate relationships. And while section 498A and section 113A were worded broadly enough to cover cruelty in the context other than dowry, the general perception was that these provisions were an anti-dowry measure. This was such a prevalent assumption that women found it very difficult to even get a case registered under section 498A for non-dowry related cruelty. That apart, the law was found to be inadequate on other fronts. One, it did not define domestic violence. As such, its ability to delegitimize socially accepted practices was limited. Further, the term used cruelty is inherently subjective. Therefore, conviction under the section depends heavily on a judge's perception of whether an act amounts to cruelty or not. Section 498A also suffers from poor implementation. This is a result of the mismatch between the legal norm enacted by the provision as the societal norms which justify domestic violence. Domestic violence is not treated as a serious offence or one that state functionaries should be involved in. As a result, their offences are rarely investigated, prosecuted or adjudicated adequately. The thrust of the state machinery is generally to counsel parties and seek reconciliation so that the family unit remains intact. This creates a settlement culture whereby such offences are seen as matters of private resolution rather than public redress. Most importantly, however, the failure of Section 498A in addressing domestic violence arises from the inadequacy of the criminal law framework in dealing with an offence of this type. Criminalization of domestic violence focuses on punishing the perpetrator but has little or no space for addressing the needs of the survivor of violence. In the specific context of domestic violence, it is important to remember that women often have limited access to economic resources and independent means of providing for herself and her children. Due to social conditioning and structures, women's access to resources is often dependent upon the husband, who is himself the perpetrator of the offence in this case. In such instances, filing a criminal case cuts off her access to such resources. She may be thrown out of a matrimonial home and deprived of monetary assistance. If it does not work in the paid economy, the arrest of the husband can mean that her sole source of economic sustenance ceases. Even if a court directs the payment of maintenance, if the man loses his job as a result of his arrest, the woman will lose access to economic resources too. Without an adequate support structure that assures her shelter and a sustenance, a woman complaining of domestic violence under Section 498A faces extreme barriers to legal redress. These problems are compounded by the slow pace of justice delivery such that it might take years for a case to be decided. Without access to adequate resources, women might not follow up on the case after it is filed. In addition, the requirement of proof beyond reasonable doubt might become a difficult standard for women to achieve, especially when there are few witnesses and women might not have access to documentary evidence to prove their case. Taken together, women rarely take recourse to Section 498A unless they are also filing for divorce. In such instances, the criminal prosecution under Section 498A then becomes hostage to the divorce negotiations. It is bartered for a better or a swifter settlement because often the immediate need for economic resources trumps the desire for punitive sanction for past behavior. An ethnographic study on domestic violence prosecutions found that, and I quote, for a woman who may be grappling with issues of finance, shelter, and children, withdrawing the case may offer the most practical solution by way of a quick divorce and maintenance. All these factors force women very often to turn into a hostile witness in the court. This implies that the complainant either denies to the court that she had ever filed such a case or declares that the case has been recorded wrongly. This not only frustrates the police who may have tried to gather evidence, but also leads to hostility towards women and reinforces the view that such complaints are unreliable and hence undeserving of serious investigation. The conviction rate is abysmally low. In fact, most cases are compounded well before they can even reach the stage of conviction or acquittal, unquote. Failure to pursue Section 498A case or turning hostile in order to seek quick resolution of the matrimonial case is often seen as a sign that the law is being misused and creates a vicious cycle of these offences not being treated seriously and more women seeking to not pursue their cases, thus added to the misuse narrative. Now look at the demand for a comprehensive civil legislation. So for all these reasons, the need was felt for a comprehensive law that not only defines domestic violence but also provides immediate support to the survivor and focuses on ensuring not only does the violence stop but that remedies provided are suited to her needs. In 1992, Lawyers Collective drafted one such law which set out the conversation on a comprehensive law to address domestic violence. In 1998, they presented a more comprehensive draft that was a result of widespread consultations with women's rights groups across the country. This draft was in accordance with the UN framework for model legislation on domestic violence. As a result of pressure from civil society organizations, the Government of India introduced a bill on the issue in Parliament in 2001. Women's rights groups rejected this bill on the ground that it contained various problematic provisions. For example, the bill defined domestic violence to require habitual assault. The violence also had to be in nature as to make the woman's life miserable, a very subjective standard. After sustained campaigning, a new bill was introduced in Parliament in 2005 and was passed as the Protection of Women from the Domestic Violence Act 2005. The rules under the Act were framed in 2006. The law came into force in 2006. Now, to look at the Act in particular, the Statement of Objects and Reasons of the PWDVA recognizes domestic violence as a human rights violation in affirmation of the Vienna Accord of 1994, the Beijing Declaration and the Platform for Action 1995, and the General Recommendation number 12 issued by CEDAW Committee in 1989. It also affirms the constitutional obligation under Articles 14, 15 and 21 of the Constitution of India to protect women from being victims of domestic violence and to prevent the occurrence of domestic violence in society. In keeping with these obligations, Parliament sought to enact a civil legislation to provide redress for domestic violence. This law is geared towards the provision of reliefs and compensation instead of being directed at penalizing perpetrators. What this law attempts is to equalize skewed power relations within the home by first providing a violence-free space to negotiate from. The Act provides a comprehensive definition of domestic violence and includes within it all acts, omissions, commissions and conduct that result in injury or harm or threats to cause injury or harm as well as harassment to meet unlawful demands such as dowry. The definition covers conduct that causes physical abuse, verbal and emotional abuse, sexual abuse and economic abuse. Each form of abuse is defined in Section 3 of the Act. The Act covers a broader spectrum of relationships as compared to Section 498A. It covers all domestic relationships defined as including women who live or have lived together in a shared household with the respondent and are related to the respondent by consanguinity, marriage or through a relationship in the nature of marriage, adoption or are family members living together as a joint family. Importantly, a domestic relationship includes relationships in the nature of marriage such as live-in relationships and bigamous marriages. A woman can file a case against any man that she or has been in a domestic relationship with. She can also file against female relatives of her husband or domestic partners. Addressing the vulnerability faced by women who complain of domestic violence, the Act takes the bold step of recognizing a woman's right to live in a violence-free home. Under Section 17 of the Act, notwithstanding anything contained in any other law for time being in force, this is what the Act says: every woman in a domestic relationship shall have the right to reside in the shared household, whether or not she has any right, title or beneficial interest in the same. The aggrieved person shall not be evicted or excluded from the shared household or any part of it by the respondent save in accordance with the procedure established by law. This right ensures that a woman shall not be dispossessed from the shared household and ensures her the basic right to shelter. A woman complaining of domestic violence is entitled to a range of reliefs suited to her needs. The court can grant these reliefs on an ex parte ad interim basis in order to provide immediate relief to the woman and to protect her during the pendency of the case. Reliefs include 1. Protection orders that restrain the respondent from committing further acts of violence. 2. Residence orders to prevent dispossession and removal from the shared household. 3. Monetary relief to meet expenditures. 4. Custody orders to provide temporary custody of children pending final determination in accordance with matrimonial laws. And 5. Compensation orders to remedy past violence. Refusal to comply with orders of the court invites penal sanction under Section 31 of the Act. This civil law sits atop the criminal law infrastructure. Magistrates using powers under the CRPC adjudication cases appeals like to Sessions Court. In addition, the Acts take a multi-pronged, multi-agency approach to redressing vulnerabilities arising from domestic violence. It puts in place protection officers who work under the court's supervision and are tasked with facilitating the victim's access to the court and assisting the court in discharging its functions. Service providers registered under the Act provide a range of services to victims such as counseling, medical facilities, etc. The state is also required to notify medical facilities and shelter homes which can provide much needed support to victims. In conclusion, in the 10 years since the PWDVA came into force, the biggest challenge to the law has been the lack of proper implementation of its provisions. The appointment and notification of functionaries under the Act remains a concern. In many states, POs are other functionaries who have just been given additional charge under this Act. Notification of service providers, etc. remains poor. Underfunding and understaffing concerns are prevalent throughout the country. Despite all these concerns, however, the PWDVA has seen a manifold increase in its usage. The challenge for the future will be to adequately train functionaries under the Act, including judges, so that they have not only the ability and aptitude, but also the orientation to implement the act to its fullest potential. Thank you.